California has a robust set of laws that protect employees from retaliation by their employers for whistleblowing activities. Employees enjoy two major spheres of protected activities under these laws. The first of these protected spheres generally can be described as protection for disclosure by the employee of employer violations of law. The second major sphere of protected activity concerns an employee's refusal to engage in an unlawful conduct at the request of the employer. Where an employee engages in either of these protected activities, whether it be disclosure of employer violations of law or whether it be the context where the employee has refused to engage in unlawful conduct, the employer is prohibited by law from engaging in retaliatory activities, which is defined as adverse employment actions. Among other things, adverse employment actions could include termination or demotion. Legally speaking, to establish that retaliation has occurred in this context, the employee must show three things. One, that the employee engaged in a protected activity, either Sphere 1 or Sphere 2. Two, her employer subjected her to an adverse employment action, for example, termination. And three, a causal link or nexus between 1 and 2, between the protected activity and the adverse employment action, which may be demonstrated by means of circumstantial evidence. Note that sometimes retaliation may not come in one fell swoop, rather it could be comprised of a series of retaliatory bites that add up to something big. All of those can be taken into consideration. If an employee plaintiff files such a lawsuit and is successful, the available remedies could include reinstatement to work, compensatory damages, economic damages, emotional distress damages, and civil penalties up to $10,000. In addition, the successful plaintiff employee may recover reasonable attorney's fees for bringing and winning the case. It's also important to remain cognizant of the statute of limitations for such actions, which in California is 3 years from the date of the adverse employment action by the employer. With regard to protected activity sphere 1, which is the disclosure of employer unlawful activities sphere, note that the disclosure of policies that an employee believes to be merely unwise, wasteful, gross misconduct, or the like is not protected. Instead, the plaintiff employee must have reasonably believed that the defendant employer's policies violated federal, state, or local statutes, rules, or regulations. The statutory scheme is broad enough that it protects both the employee himself that engaged in the protected activity and also protects any other employee that may be related to that first employee that engaged in the protected activity. So that other employee that did not do anything would also be protected from retaliation by the employer under this law. In order to make this more concrete, let's run through a very basic, simple example. Imagine we have Hector, who's an employee of XYZ company. Hector notices that the company is violating environmental laws, and he reasonably believes that that's the case. Hector goes to his supervisor, Juan, at the company, and lets Juan know that he believes that the company may be in violation of environmental laws. Shortly thereafter, Hector's hours are cut by the company from 40 hours a week down to 30 hours a week. A little while after that, Hector is written up for what he believes is an improper reason. He hasn't done anything wrong, but he's getting written up. And a little while after that, Hector is terminated by the company. In that case, Hector could theoretically bring a whistleblower retaliation lawsuit against the company for having terminated him for engaging in a protected activity. For a second example, Imagine we have John, who works at ABC Corporation as an account executive. John's mid-level supervisor insists that he cook the books in violation of law. And John declines and says that he can't do that because he doesn't want to get in trouble for violating the law. Shortly thereafter, John is demoted to a lower level position. In this example, John may theoretically have a lawsuit against the corporation, his company ABC, for having taken adverse employment action against them for having engaged in a protected activity. John stands to be reinstated. He could theoretically get compensatory damages. He could get emotional distress damages. He could get a civil penalty up to $10,000, and he could recover his attorney's fees. As with many legal matters, these sorts of cases can get complicated, and every case is fact-dependent, and so this recording should not be taken as legal advice nor solicitation to hire us. If you believe you have a case, you should contact qualified legal counsel for advice and representation. By all means, feel free to reach out to Benjy Law Corporation at 310-203-2650 for a free legal consult. You may also visit our website at www.benjylaw, that's BENJY like yellow, law.com for more information. Thanks for listening.